It is our privilege to welcome you to this interactive session conducted by the Indian Law Institute, Kerala State Unit, and the Kerala Judicial Academy. This is an academic gathering curated to explore the nuances of gender justice in the judicial system. We are all gathered here to discuss a contemporary issue, traveling through the prism of gender justice. Just as interesting as the topic is our mode of interaction. Instead of a monological discourse, our chief guest would like to engage in a constructive conversation with the gathering. We hope everyone here will make the most out of this opportunity to exchange and explore views with the legal luminary who has graced us today. Without further ado, I request Honorable Dr. Justice A.K. Jayashankaran Nambiar, Judge, High Court of Kerala, to formally commence our colloquy with an introductory address.
The chief guest today, Justice Anand Venkatesh, Judge, High Court of Madras, my brother and sister judges, both from the High Court as also from the District Judiciary, senior advocates, my young friends from the bar, the President of the Kerala Federation of Women Lawyers, Karthika, Additional DGP, Senior Advocate Gracious Kuriakos, students, ladies and gentlemen, a warm welcome to all of you today to this program which is jointly organized by the Kerala Judicial Academy and also the Kerala chapter of the Indian Law Institute. Just a word about the program. The Indian Law Institute has been organizing these programs from January 2025. We have been quite regular in having these programs, at least one program a month. So that makes this the 7th one this year. And these programs are designed or structured in such a way that they're discussions on contemporaneous legal or contemporary legal issues. And we thought this was a good way of keeping all the stakeholders in the legal fraternity up to date with issues that we deal on a daily basis. We're indeed fortunate today to have my good friend and colleague, Justice Anand Venkatesh from Madras, as our speaker, and you'll shortly understand why. He's speaking to us on a topic which requires a bit of introspection, a bit of reflection, and also maybe a reimagination of how we deal with these issues. I've often thought that in our pursuit of knowledge and knowledge accumulation, we tend to forget that there is nothing in this world as an absolute truth. We have opinions, we have perspectives, and these are all informed or formed by a person's individual life experiences. And therefore you have the well-quoted example of a person viewing a glass as half empty or half full. The pessimist would say it is half empty, the optimist would say it is half full. But that's the beauty of the language, and that's the beauty of perception. Because when you have a theory or a perspective, once we understand the truism that there is no such thing as a correct perspective, you tend to deal more effortlessly with the problems that you find in society. We deal with this on a daily basis because all the cases that come to us invariably involve two conflicting perspectives. But what if society could in general, or people in society could in general understand or step into the shoes of the other and understand the issue from their perspective? That's what we need to reflect on. Because I personally believe that if people just inculcated this attitude of tolerance, then the other incidental qualities that it would instill in a human being would be qualities of empathy, sympathy, compassion, and of course tolerance. Tolerance to the views of others. Gender insensitivity and discrimination, which my good friend here is going to be talking about, and we're all going to participate in this discussion hopefully, is just one of those issues where you find the othering of the human being is what is largely responsible for the malaise that we find ourselves in. So, how do we tackle it? These are the ideas that we're looking forward from the crowd today, from this august audience. But let me tell you what I find interesting in the way my colleague Anand deals with it, both in society as also in the cases before him. He adopts what researchers would call an ethnographic methodology. And by ethnographic you mean that you actually go and interact with the people who are victims or who are affected by this problem. So if you wanted to study something, if you wanted to study about tribal culture, you would go, as a researcher, you would go and spend some time in those tribal hamlets, interact with the families there, stay with them if possible, and understand how they live their daily lives, what are the oppressions, what are the disadvantages that they face in society on a first-hand basis. That's the ethnographic approach to research. And Anand here actually did that in a couple of cases which involved gender issues. You might have all come across those judgments of his where he candidly said in his judgment that there were concepts that was difficult for him to understand, and he actually went and interacted with those persons whose sexual orientation was different. And he tried to understand it or understand the issues from their point of view. And I think this is a wonderful approach when it comes to law, lawyers and judges. Because if you start understanding each of these issues, social issues from through that methodology, then you're basically living up to the law's ideal and law's very object of being an effective tool for remedying the ills in society. Let me stop there. I would only say on behalf of everybody assembled here that we look forward to a very insightful and fruitful discussion, and I'm sure my good friend Anand will sort of entertain us legally with this talk. Thank you.
Thank you, sir. As always, your perspective has set a profound tone for the discussions to follow. It gives me immense pleasure to welcome Honorable Mr. Justice N. Anand Venkatesh, a distinguished jurist of the Madras High Court, known for his progressive outlook, unwavering commitment to justice, and profound legal acumen. Born and raised in Chennai, Justice Anand Venkatesh completed his schooling at St. Mary's School, Perambur, pursued his BCom at AM Jain College, Meenambakam, and earned his BL from Ambedkar Law College, Chennai. Upon enrolling in 1993, he began his legal career under the mentorship of the esteemed Advocate B. Ramamurthy, later establishing an independent practice in 1997. His early years were marked by a diverse practice spanning civil, criminal, writ, and service matters before the Madras High Court, subordinate courts, and the Central Administrative Tribunal. Recognized for his expertise, Justice Anand Venkatesh was frequently appointed as amicus curiae in significant cases and contributed various scholarly articles to legal journals. His insights also shaped judicial training as a contact person for the Tamil Nadu State Judicial Academy, where he educated subordinate judges on civil and criminal law. Notably, he played a pivotal role in reforming
commercial litigation as part of the consultation and drafting committee that led to the Commercial Courts Act 2015. He was appointed as a judge of the Madras High Court in June 2018. His lordship journey from a first-generation lawyer to a revered judge is a testament to perseverance, versatility, and a deep commitment to justice. Describing himself as a judge who believes in breaking stereotypes and embracing change, Justice Anand Venkatesh has earned widespread recognition for his landmark judgments, particularly in safeguarding constitutional rights, promoting LGBTQ+ equality, and ensuring judicial accountability. His rulings reflect a deep empathy for marginalized communities and a progressive approach to the law. His lordship is admired for his humility, accessibility, and willingness to engage in meaningful discourse on legal reforms. Beyond the courtroom, Justice Anand Venkatesh is a passionate sportsman, having played cricket at senior division level for the Tamil Nadu Cricket Association, and an avid music lover and a voracious reader with wide-ranging interest. When the Indian Law Institute invited his lordship for an online session, Justice Anand Venkatesh voluntarily said he wants to come over and have a physical interactive session on today's topic, traveling through the prism of gender justice. We are indeed honored to have you here with us today, sir. The floor is all yours.
മാന്യ സദസ്സിനെ വന്ദനം. എന്നെ ഈ പരിപാടിയിലേക്ക് ക്ഷണിച്ചവർക്ക് ആദ്യമായി എൻ്റെ നന്ദി അറിയിക്കുന്നു. അറബിക്കടലിൻ്റെ റാണിയായ കൊച്ചി കുറച്ചുകൂടെ അലങ്കരിക്കുന്ന പൊൻമകുടമായി ഞാൻ കേരള ഹൈക്കോർട്ടിനെ വിശേഷിപ്പിക്കുന്നു. So, for those who are not very familiar with Malayalam, or for a majority who didn't understand what I said now, I'll just translate it in a common language which both of us will understand. I said, my salutation to this August gathering. At the outset, I would like to thank you for inviting me for this function. I consider the Kerala High Court to be the jewel on the crown of Kochi, which is considered to be the queen of the Arabian Sea. So is what I attempted to say in Malayalam. I thank the organizers. It's a great privilege to come and stand before this August gathering, because I always consider Kerala to be intellectually at a very different level altogether. And it's very emotional that so many High Court judges have come to sit and listen to this. So that shows their love and affection to me. Thank you so much for attending this. Thank you for the judges belonging to the district judiciary, the senior advocates, my beloved advocates who have come here. And I am told that there are also college students who are studying subjects apart from law, like sociology, psychology. So welcome to all of you. I am not going to stand here like a lecturer and try to teach you something. All that is not my effort at all, and that's very risky to do it before a Kerala crowd. So I will try to get into some of the basics of what we understand about the gender justice. I will speak a bit about my travel into it, how I got into it, how I traveled into it, and then I'll make it interactive so that both of us must be benefited by the end of this session. So I also want to be benefited. I also want to learn new things when I leave from here. So let it not be a monologue from my side. Just as a prelude, just as an introduction on what the Constitution says about it. Article 15.1 is the one which immediately comes to our mind. Article 15.1 is an extension of Article 14 of the Constitution. And Article 15.1 expresses a particular application of the general principle of equality as is seen in Article 14 of the Constitution. The combined effect of 14 and 15 of the Constitution of India is not that a state cannot pass unequal laws, But if a state does pass such an unequal law, it must be based on some reasonable ground, is what Article 14 is saying. And that due to Article 15(1), religion, race, caste, sex, or place of birth alone is not and cannot be a reasonable ground for that discrimination. So that's the combined effect of Article 14 and 15. These words are very important. These terms that have been used under Article 15 is very important. I'll repeat it: religion, race, caste, sex, or place of birth. These are immutable characteristics. These are things which we didn't want to be born as a Hindu. We didn't want to be born as a Muslim. We didn't want to be born as a woman, as a man. These are immutable characters which are ascribed even at the time of our birth. Something which we cannot change at all. So, we have no control over any of these terms which I said you now. And yes, a person, for the sake of argument, can say that yes, I can change it. Yes, you can change it. But it's not what you think about it. It's about how the society is looking at you from that point of view. A society will always look at me only as a male. The society will always look at me only as a Hindu. The society will always look at me only from their point of view, which is normally understood across the society. So, as such, 15(1), you find that it is immutable. It's something which you cannot change, and you cannot discriminate on that ground which you were born with, is what Article 15(1) is all about. The dignity, autonomy are the core concepts of equality. So, if you want to define equality, you can bring in dignity and autonomy, which is the core value. And to these two things, Supreme Court has now added privacy also as one of the right. So, in Joseph Stein case, so as constituting the core of the equality principle under our constitution, it is today the dignity, autonomy, and the right of privacy. And Article 21, which is another very important article, it takes all these aspects of life which go to make a person's life meaningful. So Article 21 protects the dignity of a human life, one's personal autonomy, one's right to privacy, etc., etc. And right to dignity is recognized as an essential part of the right to life, and it accrues to all persons, not because it is given by somebody, but because we are born as humans here. So it is there, vested in us, just because we are born in this place. So when you read 14 and 15 together, like what I started in the beginning, it guarantees recognition and respect for these values and a promise of non-discrimination that would have the effect of impairing them. So that's the sum and substance of Article 14 and 15 of the Constitution. How did this start? It's better that we know a bit of history about how all this started and how it ended with Article 15(1). So the earliest variants, if I would call it, is the proclamation of Queen Victoria on 1/11/1958. So 1/11/1958 is the proclamation of Victoria, where it says free and impartial admission of all races and castes into the offices of the crown. That's how it starts. So this date and month is very significant for Kerala. Kerala was born on 1/11/1956. So this 1/11 is very significant for Kerala. 1/11/1956, Kerala was born under the State Reorganization Act. And after this proclamation only, ICS started admitting Indians inside. So this date is very important. This is the first sort of outright propagation that was made by the Queen Victoria through a proclamation, where she said free and impartial admission of all races and castes into the offices of the crown. So you will find that ICS getting Indians thereafter. Then the next development is the successor Edward VII. Edward VII in 1912 added religion and religious worship as additional grounds on which no subject of the crown was to be discriminated against. And this was not because he had some great feeling for us. This was because of the violence that erupted after the partition of Bengal in 1905. And as you must know, there was a huge Muslim-Hindu unrest, and it was going out of hands. And therefore, Edward VII came in and said that hereafter, religion and religious worship are grounds in which the crown will not discriminate. So this is the next step which happened, next variant that happened. And comes the Government of India Act. Government of India Act, section 298, which is the prelude for our present Article 15.1. So section 298 of the Government of India Act, it says it prohibited discrimination in acquiring, holding or disposing of property or carrying on any occupation, trade, business or profession. The word only is a very important thing about which I will talk for 5 minutes. This word only was introduced in the section 298. So it says you cannot discriminate only on the basis of religion, place of birth, descent, color or any of them. So these are the words which originally formed part of section 298 of the Government of India Act. This section 298 of the Government of India Act came up for interpretation by the Privy Council in the famous case of Daulat Singh, AR 1946 Privy Council, page 66, where the Privy Council got into this interpreting the word only. The reason why I am pointing out to this Privy Council judgment is because even after independence, we continued to understand that word only in the same manner till about 2008. So this word only actually confused everyone, because when B.N. Rao, who wanted to bring in this word only under Article 15, there was a lot of opposition by all the other persons who formed part of the Constituent Assembly, saying that this only will create a lot of problem. For which B.N. Rao gave a very strange example. He gave a very strange example. He quoted somebody from South Africa. And he said that if a person, an Indian who in South Africa is discriminated when he comes to India, and he is discriminated, then this only will safeguard us. He did not understand that Article 15 applies only to citizens. Article 15 does not apply to any persons as is contemplated under Article 14 or Article 21. So anyway, these are all history, and this is what was brought out, and the interpretation was by Daulat Singh case. What interpretation was given? The interpretation given was that if you are able to come up with some other ground in addition to those 5 things which I said, which are the religion, place of birth, descent, if the discrimination is not only on that ground, but if you are able to find one more ground, then it said there is no discrimination. And very funnily, this was the interpretation that went on and on for some time. So after the Daulat Singh case, this was followed in Bombay Education Society case. I don't want to really burden you with judgments. I'm only trying to give you some prelude as to how it started, how it developed, and where are we today. To that extent, you will have to understand what this is all about. So after the Daulat Singh case came the Bombay Education Society case, where Article 15.1 had come into play, and for the word only, for the term only, the very same explanation was given in that judgment by the Supreme Court in 1954. So what happens is that it resulted in a very peculiar problem. The problem is, if the discriminator, which in most of the cases will be the state, if the discriminator is able to show that the discrimination was founded on not only those prohibited grounds, but something else is also there, then he can easily get away. So this approach was innocent of the principle of intersectionality. That is, where multiple grounds of discriminations are intersected. For example, race and sex in a particular case. The discriminator can get away unless the victim is able to pin him down to one particular ground alone. So this happened even thereafter. For instance, if it's on the ground of sex and also a particular cadre to which a person is employed, and if the discriminator is able to bring that person into that cadre, which is not forming part of Article 15, then there is no discrimination. So if you are able to bring in one additional factor to any of those grounds which have been quoted in 15.1, then the discriminator can escape. And this was happening again and again and again. And very interestingly, even in the famous case of Nargis Mirza, which all law students must be knowing, this was the case where for the first time the air hostess went and challenged. It's a case where there were 3 grounds which were put against them. One, you have to retire. For a male, the retirement was 58 years. For a female, the retirement was 35 years. And a discretion was given to the managing director to extend it by 10 years. 2, if you are married within a period of 4 years from the date of from the date of your appointment, then that's a ground for you to resign or they'll throw you out. Then 3 was yet another ground where if you become pregnant, thereafter you will have to just leave it. So this came up for challenge before the court in 1981. Surprisingly, you will find that even though the court went hammer and tongs on all these things, the author of the judgment is Fazal Ali. He would again get into 15.1 and say that's what exactly I wanted to say. He would say that it's not only based on sex. Here, what is the discrimination? The discrimination is you are treating a female employee, a woman employee, differently than a male employee who is doing the same work. That's the discrimination. But here, they took umbrage under 14, etc. and struck down most of the things. But when it came to 15.1, very surprisingly, Fazal Ali actually upholds it. He says that women formed a cadre by themselves. And it is not as if women amongst them are being discriminated. So since they formed a cadre by themselves, that is an additional factor apart from the sex with which they are identified, meaning a woman. Therefore, there is no violation of Article 15.1. This was the interpretation that was. Today, in 2025, we will be very shocked to hear all these things. But this is exactly where I am moving to. This is the mindset with which we were working. So this judgment, basically, even though interfered, it did not interfere on the ground under Article 15.1 of the Constitution of India. That's the most interesting part of it. So therefore, the law is if religion, sex, caste, etc. was merely one of the factors, it would not be discrimination. On the other hand, if there is no other factor, but it is only this factor of sex, religion, etc., then it will offend Article 15.1 of the Constitution of India, was the manner in which it was interpreted for a very, very long time. The evolution as such came only in 2010. So I am talking about a judgment which was of the judgment of the Fazal Ali, which was much, much earlier in 1981. And the evolution came only in 2010. Till then, courts were interpreting it only in the same way. And that's because it was the male judges who were handling it. So that's how they will look at it. And that's how they know how to look at it. And therefore, the next big shift, I would say, came in the case of Nas Foundation case. That is in 2010. Nas Foundation is a very important judgment, as you all must be knowing, where Section 377 IPC was put to challenge. 377 IPC was held to be unconstitutional by a bench consisting of Justice A.P. Shah, who was the Chief Justice, and Justice Muralidhar, who was sitting along with him. And it criminalized consensual sexual acts between adults in private. Basically, that's what 377 is all about. And they picked up this word sex from Article 15.1 and gave it a dimension where they said that sex will include sexual orientation. So they struck down 377 on the ground that it discriminated the sexual orientations of those two persons who are involved in a consensual act. So this was struck down, and they said that sexual orientation is analogous to sex under 15.1, and the most interesting part is that they drew inspiration from somewhere. They drew the inspiration from the Canadian Supreme Court. That's a case in Vrind versus Alberta. If you have the time, just go ahead and read it. I don't want to get into all those things. I'm just putting forth, I'm trying to tell you as much as possible those facts so that you will be interested and you'll go and read it. So the actual inspiration was from the Canadian High Court, which the section 15.1 of the Canadian Charter was exactly worded the same way. And they interpreted this sexual orientation to be analogous to sex. And they picked it from there. Then the next important judgment is the Nalsa judgment. The Nalsa judgment, which is in 2014. And here what is the issue? The issue is discrimination against transgenders and discrimination based on gender identity. One is a sexual orientation. Here the discrimination is on gender identity. And this is a very, very important milestone, I would say, in understanding the scope of Article 15.1. As to how you can look at this Article 15.1 was actually, it gave a hope for many that 15 can be interpreted in this way. So in this case, what happens is, as I told you, it's a discrimination against transgenders. And they said sex, identity, gender of persons, and guarantee to equality and non-discrimination on the ground of gender identity is increasing and gaining acceptance, and therefore it can be applied in India also. So here, sex is the word which was taken from 15.1, but they found it analogous to sex identity. So there, earlier 377 was sexual orientation. Here it was sex identity. So that's a very important judgment, which is a big march of law which started. And then the very important judgment is the Navtej Singh Johar judgment. Navtej Singh Johar is in 2018. So 2010 onwards, this march started. And 2014 came Nalsa, 2018 came Navtej Singh Johar judgment. And in this judgment, the lead opinion, if you look at it, it says that this judgment for the first time said that the formalistic approach of understanding the word only on the grounds which is used under Article 15 has to be interpreted in a more broader sense, and you cannot make it more formalistic, you cannot make it so restricted to understand that term. So this Navtej Singh Johar basically expanded the scope of Article 15.1. Now comes what happens after Navtej Singh Johar? After Navtej Singh Johar, how do we understand Article 15 is the main question before I get into Sushma. How is it that we are going to understand this Article 15? One, a meaningful attempt to identify and eliminate discrimination must necessarily involve the identification and protection of the constitutional values of, in the beginning I said, autonomy, dignity, liberty, and privacy. So these are the constitutional values which you have to read every time when you get near 15. Then the grounds enumerated in Article 15 are not watertight compartments to be viewed divorced from discrimination, which is the sheet anchor of that provision, and the grounds are merely instruments to find and eliminate discrimination and are therefore a means to an end. Those only and those grounds are not the end, it's only a means to an end. This is the second interpretation. Third is, the duty of a court under our constitution is to search and eliminate this discrimination wherever and however it is found. The provisions of the constitution, you cannot pettifog it by a technical or a very rigid construction like how Scalia used to do in the Supreme Court of United States. So he is an originalist. And he never appreciated this term living constitution. He was highly critical about this usage of the word living constitution. But we have always understood our constitution to be a living document, and which has to thrive, which has to meet the expectations of the society. So therefore, this march of law started this way. And the next thing which I want to say is that I told you that in Nargish Mirza, they interpreted 15.1 that way. Ultimately, that was overruled in Navtej Tagore. In Navtej Johar, specifically, it was overruled in that judgment. So today, what is applied by the Apex Court and by the constitutional courts is substantive equality standards. It's called as a substantive equality standards. It ensures fair treatment of the individual in every respect of human endeavor and every facet of human existence. So, that's the most important thing you will have to understand, and this is how it proceeded. Now I will get into the Sushma case. I was holding the jurisdiction under 482 CRPC. So this case comes up before me like any other case. On a daily basis, we used to have 200, 300 cases. Like, I'm sure that's the way it is here also. So this is a case where they mentioned for a lunch motion. So I asked, what is the problem? They said that two girls are having a life threat. So I said, okay, bring it in the afternoon. And they brought it in the afternoon. And the prayer was innocuous. The prayer was that, provide us with police protection. I said, why? Because both of us love each other. So the first shocker was to hear those words from them. And then what? I said, they said they want to live together. So the first thing that struck me was that what is the love you are talking about? What is the life that you both want to live? And therefore, the first reaction was, as a lunch motion, as all the judges here must be knowing, okay, give a protection for the present. Let us deal with this issue after some time. So the first reaction was, I called the public prosecutor. I said that, don't go near them. Let me deal with this issue. And I was sort of working with it in my mind. And in the evening, I thought, what is this love about which these two people are talking, and what is the relationship that they want to have, and as a parent, what will I do if my daughter says that she loves another girl? So these are things which started impacting me, and therefore I said, okay, ask those two girls to come to my chamber. So the next step I took was, I asked them to come to my chamber. So they came, they just sat opposite to me, and the way they were talking, the way they were glancing each other, the way they were so passionate with each other, I never felt that there were two girls sitting in my front. For a person who has always seen love between a man and a woman, a boy and a girl, I was able to see a boy and a girl there. I was not able to see a girl and a girl who are doing this. But what I found was, it was as equal, if not more passionate, more genuine in terms of their relationship between both of them. So something struck me there, that probably there is some genuineness in what they are saying, except that I don't understand any of these things. I didn't understand any of these things, and I had a very pervert attitude towards all these things. And I would not want to say anything more than that there. So, insofar as same sex is concerned, the only thing you will see is sex. And I have not seen anything more than that. So, this was the impression I got. The most important part is that I had 3 interns at that stage. 2 girls and 1 boy. So, I started talking with them. The most shocking thing was that they were amazed in the way in which I am confused about the whole thing. They were able to understand what was happening, and they were looking at me as if I'm an alien and I have come from some other planet. So I asked them as to, can you explain me what this is all about? They said, what is your problem? I allow interns to talk all these things. Many interns from here have come to my chamber. So I asked them, they said, what is your problem? I said, my problem is I'm not able to understand the relationship. My problem is that I'm not able to understand what they are saying and what protection they are seeking for, and how is it that I'm going to manage their parents? Because I asked their parents to come the next day. The parents of both the girls, I asked them to come to my chamber next day, and I wanted to somehow talk with them. So how will I talk with them without understanding this? So they opened up a new chapter in my life, where I consider those 3 interns to be my guru. There, for the first time, they opened up something new in my mind. And the next day, the parents came. The parents are the same mindset as I am. So the parents started lamenting. This girl's parents started lamenting. That girl's parents started lamenting. And they said that we come from this family, and this is what the world is going towards. This is what my girl has done to me. And I watched those 2 girls who were also present somewhere there. They did not care about all these things. They were very clear in what they were doing. And ultimately, after all these discussions, they said that we will stick on to our original position. They said, we both love each other, we both will live together, and the only request we have is whether you understand us or not, is what their eyes told me. Please give us protection. We know how to lead our life, is that was the message that was conveyed to me. So this, I kept on thinking about it. Then came the Corona time. So you had no other work except listening to Shyam Padman's daily course of lessons which used to happen in the afternoon. So the court hearings will go on screen. This will happen, and this, at some corner of my mind, this was going on and on and on. And I thought, okay, let me take this chance to understand this issue. So what I did was something which many judges shudder to do. I said that I'll go through a counseling session with a psychiatrist who deals with this. And I said I also want to talk with a person belonging to that community just to understand what is that they are trying to convey me. So what I did was that I didn't want to conceal those muck which was inside me. I didn't want to conceal those wrong notions which I had inside me. So I said that we will fix an appointment, and whatever we speak will be recorded. And whatever I speak will be recorded, taken down, will form part of my order itself. So my wife became very jittery about it. I was discussing this with my wife. She said, I don't know what got into you. As such, I know that you are not very normal, but then this is something very abnormal you are getting into. I said, just wait, let us see how this journey goes. So the first counseling I had with this psychiatrist, and I said that you just forget looking at me like a judge and all that. I'm just a human being now. Listen to what impressions I have about it, record it, and then you tell me what is wrong with those impressions and try to educate me. So there were 2 sessions which I attended like that. And the other session was with a transgender person along with the mother, just to understand how the mother underwent that journey with that transgender person. So I asked the transgender person also to record it, to clarify certain doubts which I had in my mind. And those 2 sessions, or the 3 sessions which I had, which if you go to the judgment in Sushma, you will find that I have recorded everything in that. It really changed my perspective of looking at this. One day my wife asked me, okay, fine, you have now, by then the Sushma judgment came out. I said that I am a representative of a society, this, that, all that I have written. She said, what happens tomorrow if your boy comes and says that he is in love with another boy? So I was dumbfounded. I was not able to give an explanation for that. But I told her only one thing. I told her that yes, I will get agitated. I will get disturbed. But I will understand that there is something like that. If he had told me before I underwent this experience, before I wrote that Sushma, probably it would have become violent. But today, I have undergone all these things, and there is some sort of an understanding for me as to what these people undergo. And therefore, if he comes and says, I will be disturbed. Honesty is very important when we do all these things. There is no use in acting before others and then having a different impression inside. So honesty is very important here. So I thought I will be all out honest here. And even if people look at me saying that probably this man is undermining his position, probably he is causing disturbance to the institution, the values of institution. These are all ideas which I had in my own mind. Then the way in which it was taken across the country, that was the day I understood that if you are honest, if you go and tell the world that, sir, I don't know this, and I want to deal with this issue, I want to learn something and then come out with this, the world actually appreciates you. The world does not in any way says that, how is it that you became a judge without knowing all these things? The world did not ask me that. So, across the country, they were very surprised to see the way in which I was able to travel in this particular case, in this case of Sushma, and thereafter I kept it as a continuing mandamus. I kept on issuing directions. So many developments had taken place in this case. So this happened because of a proper understanding of that word sex in Article 15.1 and what was said in Nalsa judgment about it, and the practical experience which I got from persons belonging to the community and persons who deal with those persons on a daily basis as psychiatrists. So this is a revelation which took place after the judgment in Sushma. So the psycho-education, undergoing a psycho-education and writing an order is something new which happened, and I somehow, some force made me do all these things, is the only thing I can say here. Likewise, the other issue about which I had a problem was the POCSO cases. So, as you all know, POCSO was a protection given to the child, which also deals with a protection under Article 15.3 of the Constitution of India. So, this is a special law for the child. The same 482, I was sitting in this jurisdiction for a very long time. So, the same 482, I find a case for quash on compromise. And I was looking at the cause title. The cause title said petitioner complainant, respondent accused. And complainant is asking for quash on the ground of compromise. I said, is there a problem in the cause title? Or they said, no, sir. The complainant is the mother. Mother is the person who gave the complaint. The mother wants it to be quashed on the ground. I said, how can this happen? So I asked the parties to come to court. And the mother comes and says that my daughter is now studying. I want to get her married. This pendency of this case will have a problem for her future. So therefore, I don't want to continue. I said, please bring the girl. When I spoke with the girl, she said that I was chasing this boy. I was the one who developed this relationship with this boy. She was very honest. She said, I was the one who chased this boy. I only developed this relationship. The boy was telling me that, see, I am an auto rickshaw driver. You are studying in the school. And therefore, this may not work at all. But I was putting so much pressure on him that at one stage he conceded to it. And once this fact came to the knowledge of my family, they started looking for marriage. So I went to him. I forced him. I told him that you will have to take me today out of my home, or else I will commit suicide. So the fellow was not able to say anything. So he took her, police complaint, police traced them, brought, girl went to her house, boy went into the jail. So the girl said, he is not to be blamed at all. At the time when she said this, she was almost touching 18. She was 17 and odd. And it was a lot of clarity with which she was saying it. So the first thing which came to my mind is that, is this the objective of POCSO at all? Is this how we have to deal with POCSO? So that's the next case where I dealt with in Vijayalakshmi as a state. This is in 2021. One thing which struck me was that the presumption under section 29 and 30 of that act, if you read it as it is, it will look as if FIR is enough to punish a person and send him inside. That's the impression that section 29 and 30 will give. And the punishments are no less than 10 years, 20 years, etc. So I thought, a person who otherwise was very normal, a person who otherwise was not a danger to the society, does this person get into a jail for 10-20 years for a transgression which happened with consensus? It's a consensual relationship. And will he be inside the jail for 10-20 years? And is that the intent of POCSO? Was the one which actually had an impact on me. So that is when the next journey started with this POCSO. And what I did started spreading across all the other judges. In all cases we started calling, and we found to our shock that in Nilgiris, all of a sudden, the number of cases which were registered under POCSO shot to 950 or something. It gave an impression as if in Nilgiris all children are molested. And when we go and inquire, they say that these are the Toda tribal people who were marrying at the age of 15 and 14 and 16. And when they come to the hospital after getting pregnant, section 19 mandates the hospital to inform it to the police. And suddenly they find their husband inside jail. So this was another shocker which was parallelly happening. So what I saw in that scenario was that POCSO was going away from its object itself. POCSO was virtually getting away from its object, and the majority of the cases with which we are dabbling are cases of relationship between two teenagers who are in a romantic relationship and who are under the influence of their hormones. So I was just thinking one day as to what would have happened if I had got into a position like this. I think that's the best test you can apply. Like the first test which I applied to myself as to what will happen if my boy comes and tells me that he is in love with another boy. Same test I applied here also. And I thought, for that so-called transgression, that's a period where the love, when it gets into a physical relationship, and considering the present day, the chances of the girl and the boy meeting each other, it's not that difficult. The difficulty of a girl and boy getting together is not very difficult. And in a relationship like that, if this happens, will that boy go into the jail for 10 years and 20 years? And therefore, I was thanking God that I did not get into a problem like this. It's very easy to criticize others. At your age of 50 and 55, you can always say, where is this society going? Where are these girls going? Except this, that. We don't understand that we were exactly like that when we were 17 and 18. At least I was not there in Himalayas sitting and meditating. I can be very clear about that. So, when you understand the scope of that word, again I am getting into that word in Article 15, I understood it only because I had put myself into the shoes of that teenage boy who had a real romantic relationship and who was caught because of circumstances like this. I quashed that case. The other case which came up before me was, there was a boy and girl studying in the school and they were in love with each other. What happened was, the friends wanted them to get married, a tamasha marriage, in a bus stand. So he simulated as if he is tying a thali around the neck of this girl. This they took it in a video, they videographed it, and they had spread it in WhatsApp, as we always do. And then came the society which said that we don't know where we are going. The boy was 17 years. The girl was 16 years. And the boy was arrested. What the police didn't understand is that POCSO is sex neutral. There is no girl boy in POCSO. The word used in POCSO is child. A child can be a boy, a child can be a girl. The boy was arrested. And a habeas corpus was filed. and that habeas corpus was dealt with by us. Until today, we are dealing with that habeas corpus to give continuing mandamus, where we are also using that power to quash wherever we identify cases of this romantic relationship. And you will not believe me that more than 60% of the cases involves boys and girls below 18 years. Is this the object with which POCSO was enacted? Is the question. And the latest version of what happened in our court is this movie in Telugu, if you had watched. This is called as the People versus Nobody. You will find that movie, probably they should have got the copyright from me. They projected that movie as a story. Actually what happened was that the story involved in that are the facts of this case. And whatever was said is the observations that were made in that order. But in any case, it has now brought a lot of awareness among people as to the scope of this POCSO Act. So this is another very important thing which happened. And the third part of my journey is the one which happened last week. I know probably you had read about it. This was a case where a boy and a girl had a relationship. The boy had perversion in his mind. In a particular encounter with each other, he videographed the whole thing. So he had sent it to all the social media groups, this and that. It went to such an extent that it was distributed among almost 70 networks. It got into the pornography websites, and it was distributed all across. And people started looking at that girl very differently. She is now a practicing advocate in the High Court. So the prayer before me was to direct the government, the central government, which is the authority, to remove all those things from the website, etc. While dealing with this case, I was halfway through dictating the order, the open court, because I wanted something to happen immediately. What came to my mind was, if this was my daughter, if this girl, who is now before the court, was my daughter, what happens? Sort of I choked. I was not able to take it. It took me 5 minutes to really regain my normalcy, because that particular question which I had put to myself told me the impact it will have on somebody who was having a relationship with the boy, and she never expected the boy to set up a video camera and record all these things and send it across. And she comes and says me that he did not just do it with me, he has done it with 5 more girls like this. And out of those 5, 4 are married, and 1 person is married and pregnant and living outside. So this is a huge problem that has now come up. And what is the lesson I learned? That evening I called that girl to the chamber. I spoke with her for 15 minutes. And when she was leaving my chamber after 15 minutes, I would say that that is the greatest experience or a greatest happy moment that I will have. She said that if at all I want to continue to live in this world, it is only these 15 minutes which changed it. So this is the impact which a judge can create sitting in a constitutional court by looking at provisions of Article 15.1, Article 15.14, etc. It is not the letters. It involves a lot of emotion behind it. It involves, you will have to, like what Elvis Presley said, you will have to walk a mile in my shoes. Only then you will understand what the problem is. If you keep on walking in your shoes, you will always look at it only from that perspective. So, while dealing with these issues, what I found was that it's a 3-step process. Process 1 is you identify the discrimination. Process 2 is you identify your confirmation bias. And process 3 is you try to find a solution. The only way you can do it is you must have that empathy, and you must have the attitude of stepping into the shoes of that person and looking at the problem. That's the only thing. And the last one is one which came because of a lot of hue and cry which came after the All India Judges Association case in 2025. This was a case where the Apex Court has upheld the 3-year practice in order to get into the judicial service. I heard about it. I read some articles about it. I was not getting into any opinions about it because there were lots of opinions that were coming from all sides. But I realized the importance, or I realized the problem only after the interns started talking with me about this. As I told you, the interns come to my chamber across India. So these are all interns from whom I learn a lot as to what is actually happening in their minds, in their young minds, what is that is happening. So the intern, one or two interns came and told me that the only chance we had to get into the judiciary and establish ourselves was that you allowed us to get into the judiciary without an experience. And today, you have imposed a three-year bar experience as a minimum qualification. 2-3 questions which they asked, I was not able to give an answer. They said, 1, in 3 years, what is that we learn, sir? 2, in 3 years, in most of our cases, they will get us married. 3, in 3 years, we will not be able to earn at all, and the members of our family will not be able to understand the nuances of this profession. They don't understand anything. At least earlier, when we got into judicial service, we had a dignity. We had some status. We had an income for us. And therefore, our position was much, much better. But now you have pushed us to a stage where most of us will have to move out of this profession. So that's when it really hit me. I thought, oh, there is an angle like this which has to be seen in a case of this nature. So they wrote some articles about it. They were not able to express themselves so much before me. They wrote articles. They gave me those articles. And they said, sir, it's very easy for you to say from here that you need 3 years. But sir, please mark my words. In the coming 10 years, if you are going to continue with this, you will find that women will go back to square A. And she said, don't understand this problem from a city point of view. Please understand this problem from town, from Mofussil, from districts. There the scenario is very, very different is what they said. So what came to my mind is this concept of indirect discrimination. I cannot give opinions here considering my position. But what struck me was something called as an indirect discrimination, which is there are invisible inequalities which are prevailing in the society. And if those invisible inequalities is going to result in discrimination of a person, that is also a ground which can be interfered. And if you are interested, you can go and look at this judgment in Lieutenant Colonel Nitish's case. This is 2021 judgment where the Short Service Commission for the women, they were discriminated as against men. Then the 2019 judgment where a lady cleared an essay examination. By the time the physical test came, she became pregnant. So therefore, she was asking for extension of time, which was not given. There, per se, there was no problem with the rule. But then the inherent discrimination or the inherent problem faced by the woman was taken into consideration and that extension of time was given. So this indirect discrimination is yet another issue which is really growing in strength. It was at a very nascent stage earlier. Now it is picking up its worth. And this is yet another judgment where I thought probably we should have looked at it from the standpoint of view of that young lawyer who wanted to pursue it. So with these few words, I want to make it interactive. Thank you.
Thank you, sir. Your words have undoubtedly broadened our horizons on the subject, enriching each of our roles in the dispensation of gender justice. I request anyone who would like to interact with our chief guest to kindly raise their hands so that our volunteers with cordless mics can find you.
Yes.
Thank you, sir.
See, we are talking about NALSA judgment, Sushma, and rights of third gender. See, Indian laws substantially mainly are binary in nature. They recognize only two genders, male and female. Of course, in NALSA, the self-perceived identity of the third gender has been identified as part of Article 21, of course. But still there are a lot of ambiguity to the applicability of various laws to this transgender community. like especially personal laws. If you look at marriage laws, inheritance talks about Hindu Succession Act, talks about inheritance of male, inheritance of female, and even law related to adoption,
Correct.
guardianship. Even if you look at the penal laws, talks about raping a woman. And in BNS, a new provision is introduced, section 69.
Yes.
It's a deceitful means or promise to marry
Yes.
a woman. What about in those cases where the victim is a transgender? And what, especially in personal laws, which branch of law, whether these provisions would be applied to transgenders? When a transgender dies, which, if she is an Hindu, which is the provision that would apply? And of course, in Madras High Court is the first judgment, Arun Kumar, where a marriage between a male and transgender woman was recognized. What is your thought about it? I just want to.
If we are to understand this issue properly, I think we'll have to understand how we were looking at persons who are suffering disability. Let's start from there. Persons suffering from disability, what all names we used to call them when we were young? When we were young, or the generation before that, we never had even the minimum or the basic respect of identifying that they were born with that. So what happened was, there was a lot of awareness that was created, which ultimately resulted in People with Disabilities Act. So with People with Disabilities Act, today with this generation, and most of us in our generation also, we are now calling them with respect. We are now calling them by saying that these are differently abled persons. We don't call them as handicapped person. We don't give them those names. So it requires a lot of awareness in the society for the law to work first. Conflict with law. For you don't call it as a mentally retarded. You call children in conflict. So it requires a lot of awareness in the society for the law to work. And particularly in cases of this nature, because it's always binary, and the society has always seen it in this way. We have always been taught in the particular way right from the time when we were young. So it's very difficult to get out of that subconscious here. That is why that big dispute is going on as to what happens after your relationship. After both of you getting into a relationship, okay, nobody will interfere with your relationship, you will be given protection, nobody will have any problem. What happens to your personal laws thereafter? That's the moot question which was before the apex court. Here again, if the court had attempted to come up with some law, it would have become unworkable under the given circumstances. A law if there is a law, the law must be capable of being worked in the society. Without that, you have a society which is not even identifying it, which does not want to even recognize it. Then you will always have a dispute. So it involves an evolution for the society to get into a mode like this. For this, what I have done in one particular order is that I have come up with this concept of a familial agreement between the parties. So, the parties can enter into a contract. No law can bar an agreement between two parties unless it is spelt out to be void under the Contract Act. So the Contract Act has to say that these agreements are void. The Contract Act also spells out all those things which are void. Yes. So if two persons agree to enter into an agreement in that relationship, and they agree to deal with their bank accounts, their properties, etc., in those agreements, and if that is given a teeth of law, probably that is one way in which you can bring about some recognition in their rights which falls out after they get into a relationship. So that process is now happening in Tamil Nadu. Already the format familial agreements have been it forms part of that very policy that is going to be brought out by the government, and the government is going to come up with a law saying that it will have, if the agreement between the parties is recognized, it will.
If it is routed through
Yes.
ADR mechanism,
Yes.
and if it is passed under the Mediation Act or Legal Services
Yes.
Authorities Act, it will get the seal of a court, verdict.
The one advantage which I am having there is that I'm trying to slowly build it brick by brick. I am not giving directions to the government. I am requesting the government every time as to why don't you think it in this way. And they also do it, and they are going to come up with two different policies. One policy for the transgenders, trans women, other for the other community. So here, when it comes to the other community, they don't have an inherent discrimination like what a transgender person faces. It is only the sexual orientation where they have the problem, and which gets out only when they tell it to the world. Or else, per se, there is no discrimination insofar as education, insofar as getting all the other facilities, there is no problem. The problem starts only when they spell out their sexual orientation. So there, in order to develop that relationship, this familial agreement is something which is being suggested, and I am in some time I think Tamil Nadu government is going to go ahead and do it. If it is done, it will be the first time in India. So that's one way of handling this. To really, for a court to come up with a law, I think the court will be transgressing its powers. It does not have such powers. The court can only try to say that you have entered into an agreement and this is what will be the effect of that agreement. If that is done, probably it will set a precedent for the future evolution. And it's not a case which is peculiar in India. Across the world, even in the so-called the senior most democratic country in the world, USA is not able to agree it. They don't agree. The two parties are completely in split only insofar as this issue is concerned. So therefore, till we are able to step into their shoes and look at it, till we are able to get a solution, till the society understands it, and I am sure that the future generations will understand it much, much better, because after all these orders, my son was looking at me very naturally. He said, "What's the big deal you are doing?" That's how they are. They are born this way in this world, and you have recognized it. So don't take so much of credit to all these things, is what he said, and he left. So I take him as I'm taking him as one of the samples of the generations that are now. They are able to recognize this. They are able to identify it. But it's going to take a long time for all these things to happen, because lawmakers, in order to do it, must have the backing of the society. And lawmakers themselves are persons who are male. Every problem is because we are all male. And we only know to look at it in a particular way. Anything apart from that is an aberration for us. So it's going to take a lot of time.
The Supreme Court recognized adoption by same-sex couple in that Supreme Court judgment, though same-sex marriage is not recognized.
Correct.
Sir, can I have a doubt? In the scenario of gender identity, such as male, female and transgenders, what are the new innovative steps taken by judiciary apart from constitutional privilege for the gender equity?
I think judiciary is not a lawmaker. Let us understand where we stand under the Constitution. Under the Constitution, the three limbs are perfectly delineated, and we are not supposed to be making laws here. But what the judiciary can do is that the judiciary can be proactive. The judiciary can push the lawmakers to do something by telling them as to what the real position is, or real condition is, and make them act for it. And what the judiciary can do is, they can deal with the case which comes before them. Kerala High Court did it. For a case which comes before you, you can render justice to them. But is it possible for a judiciary to spread it out to the entire community, for the entire state? It's impossible. It's not
On
possible.
the basis of the Constitution, sometimes judiciary fails to identify the psychological issues of transgenders.
Correct, because we are also human beings. The reason is very simple. Persons who are sitting there as judges did not fall from the sky. We are after all human beings. And we are having all problems that are faced by regular human beings, like our confirmation bias, this bias, that bias, preconceived notions. We suffer from all that. But the greatness is to somehow identify it and get out of it. That's the struggle which every judge undergoes here.
Humanity fails sometimes before the law.
Yes.
Hi, sir.
Yes.
Good evening. I had two questions. One is, what is your definition of gender justice, and how does it differ from gender equality or gender equity? And the second one would be, sir, when you heard about the other genders and everything, you went for a counseling, right? So similarly, how can the common people, like we all are already, like we are into it, but when it comes to our parents or our other relatives, how can they incorporate this change as well?
I'll answer the second question first. As you age, it's very difficult to change oneself. That's at least experience is telling me that. As you age more, it's almost impossible to change oneself, because you have created so much in your subconscious. Your impressions in the subconscious is so much that you will not even feel that you have such impressions within you. You will always try to justify it. In Tamil, we used to have one saying, "Aindil vilayadadu aimbadil vilayuma," which means that if something does not change when you are 5 years, it is impossible to change at 50 years. So the more you age, the more it's a problem. So therefore, as a strategy, what I do is that I don't discuss any of these things with elders at all, because it's a lot of energy waste. It is not going to happen. So I try to discuss this with people who are willing to listen to it and think about it. And I am very happy to discuss it with youngsters, because I am able to find that the youngsters are able to understand it better. So therefore, my target is always these youngsters, because after all, in the future, it is only you who are going to rule it. All our old bandicoots will go out of this place. It's impossible to change them. So to ask parents to undergo, yes, nowadays I find that there are some parents who undergo it. Some parents who undergo it, they support such marriages. There is a lot of change which is happening, but it's happening once in a while. It's not regularly happening. Second is on the gender. I think basically one has to try to differentiate between sex and gender. We are born in a particular sex. We are identified as a male. We are identified as a female. But gender is something which the society is ascribing to you. So those famous wordings where they said that I was never born into this world as a girl is a famous saying. So you are continuously telling me that I am this and I am that. So the gender per se is something which the person identifies for himself. So if there has to be a gender equality, there is nothing called as a gender equality. I'll give you one recent advertisement which shocked me. This is this famous good-looking macho hero in Hindi movies. He suddenly gets into one house and he tells the lady as to how she has to clean the toilet. So I don't want to name him, but he gets into a house and he tells her that it's very easy to clean toilet with a particular liquid. And I was searching in that frame as to whether there are any male. There was no male at all. So what is that advertisement trying to tell us? It is trying to tell us that toilet cleaning is something which is related only to women. So I again see one more advertisement. In that one more advertisement it says, the tasty basanti rice with the flavored vegetable thing. And who is that person who is saying it? It's a female who is saying it. And I also see a female in a makeup advertisement. So what is the society talking about this gender equality? It says that you clean the toilet, you cook, you also maintain your beauty, is what it says. And there is a very interesting episode which happened in a classroom. So what they did was they asked the children to draw whatever was told to them. For instance, when they said teacher, everybody drew a female. When they said fire engine man, when they said fire engine, they drew a man. So so things like this went on, and at that age, they were only able to identify that these are the works which are tasked only for men. These are the works which are tasked for women. And it starts at that age. Where is the equality? Where is the equality? Meaning, if a girl is to go in a late night bus and reach her place, and she gets down, what happens if it's a boy? What happens if it's a girl? When a boy gets down, his only worry will be, he will be missing his sleep. He will be worrying about what food he will get. Okay, we will now take away that boy and put that girl there. The girl, the problem starts right from the time when she gets down from that bus. After she gets down from that bus, the first challenge she will face is, who is coming behind me? Second challenge she will face is, what will the elders in that house ask her? What types of questions do we ask her? We ask her as to, where did you roam around the entire night and came today? We don't ask such questions to the boys at all. So, we are continuously talking about gender equality, and that gender equality can be achieved only if those normative perceptions goes away. It's going to take a long time. It's going to take a long time. And the person who is sitting here and talking to you, even for me, those seeds are somewhere available within me. At an appropriate time, it actually comes out. And I'm not ashamed to accept any of these things. I don't feel ashamed at all. I have problems. Unless and otherwise I identify that I have problems, I cannot change at all. No? So I have these problems. So a person who is trying to work himself out of it has so many problems. Think about a person who does not even think about it. So this gender equality, the gender identity, all these things today has become a fashion. But how many are really working towards it? I leave it to you.
Good evening, sir. My name is Meera Madhu. I am a second year BBLLB student from Cochin University, and my question is that, so far from what you've spoken, I've developed this idea, and so have my peers, that each reminder surrounding our personal laws to be reformed for greater gender justice. So such reforms would obviously be met with much protest from various communities, particularly in the name of religion. So is it likely that there can be a meeting point for these reforms, wherein these reforms aimed at wherein these social reforms aimed at gender justice are not going to hurt religious sentiments?
There is a lot of misunderstanding in understanding this word religion itself. If you look at the source of this word religion, the root is, it's called as religer, which means that getting back to oneself is what the meaning of this word religion is. That is what is happening is the question. The question is, in the name of religion, what all we do? We identify ourselves with religion, and after identifying ourselves with religion, does it make us a sane person? Does it really help us in our evolution? What is happening is that in the name of religion, we get so attached to religion, and we think that all the other religions are all enemies. And for some reason, it is being sort of cultivated, and therefore the youngsters are now totally confused about taking up religion. For instance, many a times my son asks me as to, what is that you are doing by standing before that God? What are you asking him? I said, I am asking him for peace. He said, why are you asking him? You find peace in yourself. So, religion, if it is going to help a person to evolve, it will help you. But if the religion becomes a cult, If the religion says that you will have to do A, B, C, D, E, and this A, B, C, D, E is done for what purpose you don't even know, then you get into a cult and you start identifying yourself with the religion, and your ability to think independently to that extent is taken away. So when it comes to this gender again, it all depends on how that religion treats its gender. That's where the problem starts. So if you ask me for a straightforward answer, I would say that it's better to understand gender justice by moving out of religion and trying to understand it.
My question is with regard to incorporating gender neutral ideas in children's curriculum and the manner parental rights would be affected. If I hear a lot of parents concerned about children being confused when gender identity is introduced into the curriculum.
Correct.
Similarly, a lot of parents have concerns about their religious beliefs being hampered, which are protected under Article 25, when gender neutral concepts and gender roles are being tarnished from the education system. So how would you conceive to incorporate and reconcile between these varying concepts, sir?
In the course of my hearing, I told you that the Sushma is continuing as a continuing mandamus. So one area which was identified is to inculcate it and bring it at school curriculum. So directions have been given to NCERT about this. NCERT in fact came up with a curriculum and it has been kept on hold for some time. Some discussions are taking place. So the reason why I did this was what you said, that it has to start from the school itself. Nobody can just pick it up when they are 20 and 30. It's very difficult because by then you have formed a lot of opinions in your mind, and to reverse it itself, it takes the whole of your life. So the best way to handle it is to somehow start it at the stage of school itself. So NCERT was directed to do that. In Tamil Nadu, at the school levels, directions have been given to identify teachers in a school who can be approached wherever a child encounters a problem of gender. Because the child must know where to go and talk about this. Parents, they are not willing to hear. The friends, they are not matured enough to understand about it. So they must have somebody to go and talk. So what happened was that I created this, where teachers will be identified from school, and those teachers will listen to them. The teachers are not the specialists. They will listen to them and they will help these children. They will take these children to the concerned person, try to explain them, bring their parents in, try to explain them that there is nothing unnatural about the whole thing. So it's a process which is happening that way. And as I told you, these are changes which will not happen that fast. These are changes which will take a long time. But we have to keep on knocking that door. Only if you keep on knocking that door, someday the door will open.
So in the hypothetical event of an Article 25 challenge being posed by one of the parents against such a curriculum being introduced, so how would you consider reconciling between the 25?
I think I can answer it after my retirement only. Here I am getting into area where if it comes tomorrow, then what happens? So when you are putting questions, don't get into such nitty-gritties because it's very difficult. Because once I give my opinion, it becomes difficult for me to handle a situation like that.
Justice Venkatesh.
Yes, sir.
I mean, after listening to your examples, I'm more keen than ever to now meet your son. But how far do you think that the problem that we're facing in society and the legal issues that we grapple with, how much of it can be actually solved by the legislature if they just use sex instead of gender in the statutes? Because if you remember, even the Constitution uses the word discrimination on the ground of sex. It doesn't say gender. If you confine to just the male and the female instead of man and woman, would that not to a large extent prevent or help the judiciary in interpreting the laws based purely on sex, and you can avoid the confrontation with gender?
It's not that easy is what I found. During this travel which I undertook, there are many who don't want to be called as men, women. There are people who don't identify me as a man and woman. That is when I understood that there are more complications in this. There is a lot of identity in this which gets into it, where from our standpoint of view, we will be able to identify it easily. But from their perspective, it becomes very difficult for them to accept it. That is why when I directed them to come up with this glossary of words that has to be used, it became a huge controversy. Because one group was giving particular words by giving it a particular meaning. And from the community, they come up with a completely different meaning to it. So then I understood that it is not that easy to tackle this, to handle this. So as you rightly say, to start with, we can do something like this. And we can keep on evolving this and see where it goes. At the end of the day, I think judges must also be open to this. Let's be frank about it. It's not all judges who are interested about all these things. Because at the end of the day, the judge is a human being per se. He has his own... so therefore, if a judge before whom this Sushma case could have come, he would have said that they both are adults. Just give them police protection. Criminal will be disposed of. It need not have crossed 5 years, and it need not have reached a situation like this. Issue is how many will be able to look at it that way. That's the issue. So it's and we all belong to this society. We are all samples of this society. We are not born elsewhere. We belong to this society, and most of our notions about understanding this falls from how a society understands it. That's why in that order I said that I am a representative of the society, and my awareness about this issue is the awareness which the society has today. So I am the sample of that society is what I wrote. So it's going to be a long journey, but I always think that discussing about it, talking about it, making people think about it will help us.
Good evening, sir. My name is Shruti Sitara. I am a transgender woman. You said that younger generation will understand the scenario way better. Yeah, I do agree, but besides all the fact that we are capable of doing all the things that a cisgender person can do, we are nowhere inferior than a man and woman, and we are not harmful to society as well. So the younger crowd in our country are spreading campaigns about the wrong information about queer community just because they are not ready to accept the fact. So how do you think the queer phobia among youngsters can be cured?
Social media is a problem even for judges. Social media is a problem for everybody who is in the vulnerable section of the society. So we do not know whether it is actually the youngsters who are doing it. We are not very sure as to who is actually posting it. You can project yourself to be an youngster, but it may be a 70-year-old man who is doing it. We don't know who is doing it. So the problem with social media is that you are not able to identify the person who is doing it. So it's very difficult to say that it's the youngsters who are grouping up and doing this or creating a queer phobia in the society. Today the influencers and the people who take advantage of this social media is so much that it becomes impossible to identify them. So social media is going to be a big problem. So the only way to understand is to talk with youngsters, understand their perspective about it, and the extent to which I have spoken with them in the last 5 years. Without any hesitation, I can say that their understanding is much, much better. It's not the way in which you are looking at it. Therefore, don't get so discouraged looking at social media. Because if that is the case, we will not be able to perform our job at all in the court.
It's not because they are unaware, they know everything, but their prejudiced mind are not ready to accept it.
That they is the issue. Is that really youngsters is the issue, is what I am trying to address. Is that really the youngsters who are doing it, or somebody else is doing it? Today, anything and everything can be influenced by a group of persons. They can keep on creating messages, They can keep on doing it in rounds. By the time you realize there are already 15,000 messages. And those 15,000 messages are done by a group of persons from different places. So, my explanation would be that it's very difficult to assess it from a social media point of view. That's all. That's what I'm trying to say.
Good evening, sir. My name is Snigdha Raja. I'm a fourth-year law student from Nuals. Sir, I wanted to know your opinion on Suprio versus Union of India, the same-sex marriage case.
After retirement.
Okay, sir. Thank you.
After it. Reserve certain questions after it. Provided High Court calls me.
First of all, heartily congratulations and thanks for the justful intervention. My name is Heidi Sadia. I'm a 27-year-old trans woman. I'm studying in St. Teresa's Women's College. The Supreme Court an year back has come up with certain words which were gender neutral. Albeit unsuccessfully implemented.
Correct.
How can the judiciary and judicial activities be more LGBTQ inclusive?
Actually, there is a lot of awareness even among the courts. The problem is that courts cannot adorn the role of an executive here. We must know our limitations. Ultimately, we must be passing orders which are capable of being implemented, which are capable of being acted upon. Even I undertook this journey of identifying gender-neutral words, etc. I gave directions to the media. I gave directions to all concerned to use those words. To an extent, it brought about some awareness. And today, when inappropriate words are used, there is a lot of opposition which takes place. So, that awareness has been created. Will the court be able to ensure that it continues? Court, among the other, a lack of cases which is coming before the court is also dealing with an issue like this. So, it's very difficult to really pinpoint and focus only on this. If this is the only work a person does, it's possible to do it. But there are a lot of other things. And that's why I said that it's a team effort. The court has to see to that an awareness is created. The court has to pass orders which are workable orders. A court should not pass orders where they will get applauded from all concerned. But ultimately the order is not able to be implemented. That's the most important. That's why I did not want to write the order in that. I could have easily written, I had NALSA already with me. I had NAS Foundation. I could have picked up words from that. I could have picked up words from the international forums, and I could have written it and people would have appreciated me. But that would not have stood time like what it did now. So therefore it's a continuing process which has to take place, and courts to a great extent can do it. But the problem is the number of cases which we handle, the jurisdictions we handle. So it's not the court by itself which can do it, is what I am trying to say.
NALSA have schemes for the betterment of this general people.
Correct.
And we execute it through DLSS and the state legal service authorities.
The one thing which I can say is that if at all there is some awareness about it, if at all there is some sort of an understanding about it, it is only because of the courts it is happening. You must be very thankful to the courts for it, because it's not happening from any other branch of... yes. That's all. Yeah.
Good evening, sir. My name is Anand. I'm a third-year law student. So my question is that, what are the problems that will arise by making the laws that are meant to protect women gender neutral? Like, for example, when I'm talking to my male friends about topics like rape or domestic violence, the question they most often ask is that, what about the men who get raped? They do get raped or sexually assaulted as well. So, but I do not know, I know for a fact that these laws are meant to protect the women, but I don't know how to answer their question.
That's why I said gender should not be just identifying girls into it. Gender includes male also. So there are problems which are faced by male. For instance, a typical problem which arises in the society is, at least the girls have the independence of being independent, at least till marriage. But for a male, at the age of 20, they start throttling you in the family. They want to take care of the family, they want you to do this and that. The independence which they are seeking for, they don't get it. There are problems faced by men also. But what we are looking at is, which is the bigger problem? We are not talking about there are no problems for men at all. We are looking at which is the most disadvantaged section of the society. So that is where the focus is. And at least for a male, there is a support system available in terms of family, this and that. But for a woman, the discrimination continues in every other place where the woman encounters. Let it be the educational institution, let it be the marriage institution, let it be the office to which she goes and works, right through. So that's the issue, which came out beautifully in this movie, this Malayalam movie called as Great South Indian Kitchen. My God, it was like a slap for me when I watched that movie.
Good evening, sir. Myself, Adishta. I don't know if you remember me, but I also had the opportunity to intern with you.
I know you.
I have a question for you, sir. I had an opportunity to read one of your articles which talked about the mandatory 3-year practice that the fresh law graduates have to undergo before they become the junior judges. So if you have to give one sort of empowering statement to a lot of girls here to still pursue judiciary at this juncture, at least, we don't know, maybe there could be petitions that come up in the future, maybe by the time hopefully I graduate, but still any message for us, sir, to still pursue judiciary?
This profession by itself is all hard work only. There is no guarantees in this profession at all. This profession has no such guarantees. The only reason why I said that women will be disadvantaged is because only after this 3-year was taken away, there is a semblance of presence of women in judiciary. And you look at it, when you look at the district judiciary itself, for instance, Tamil Nadu, Kerala, we have more than 60% of judicial officers who are women, who otherwise would not have come into this profession at all. And you will also find that that number is so big in the entry level, and it dwindles as it moves up, and it is almost negligible when it reaches the Supreme Court. If that is the case that is how women are being handled in this institution, even when they have an opportunity of getting into judicial service immediately without those 3 years, what will happen if 3 years is put against them? That's the question. If 3 years is put against them, then there are so many permutations and combinations which will prevent them from getting in. If it prevents them from getting in, what are those empowering words you want to say? I want to say that good luck to you. Good luck. And I only hope that your family understands it. I hope that you have the wherewithal to withstand that pressure. You have the braveness to tell your parents that to hell with your marriage for some time. There are lots of things which will now come to you. And you must also be very lucky to get into an office which gives you an opportunity. So therefore, I summed it up by saying good luck.
Thank you, sir, for taking us all on this journey through the prism of gender justice. It has been our distinct honor to have Hon'ble Sri Justice N. Anand Venkatesh, Judge, High Court of Madras, to lead this interactive session. As a token of our gratitude, we would like to present a memento to our chief guest. To do the honors, I request Honorable Dr. Justice A.K. Jayashankaran Nambiar, Judge, High Court of Kerala, to join us on the dais. Thank you both. As we move to the end of the ceremony, I invite Shri Sujit KN, District and Sessions Judge and Director of the Kerala Judicial Academy, to deliver the concluding remarks.
Honorable Mr. Justice N. Anand Venkatesh, Honorable Dr. Justice A.K. Jayashankaran Nambiar, Judges of the High Court of Kerala, my dear judicial officers, respected AG, respected senior advocates, my dear lawyers, students, absolutely fantastic students, young brains, young minds. I have seen today, good evening to you all. Sir, after this program, standing here, I feel so proud that we have hosted a program like this. Both from the Kerala Judicial Academy as well as the Indian Law Institute feel proud because what we saw today is an absolute masterclass with splendid clarity. The message, the thought-provoking things His Lordship has conveyed to us is a real eye-opener. I was so fascinated when the two persons from their own community asked the questions with precise, their struggles they have sketched out before your Lordship given the answer with that exact precision, that because what we saw today is not sheer lecture. It's a lived wisdom. Lived wisdom after staying with them for some days, just to know about their struggles, their joys, their rhythm of life, so he can resonate with their mind. That is what we could see today. Your Lordship, you have displayed your erudition, you have displayed your thought-provoking things on this particular topic, traveling through the prism of gender justice and absolute topics of relevance today. Your Lordship, you displayed here, you have shown us what you are, with all on behalf of all who gathered here, I express our deepest gratitude for the magnificent display of things here. Honorable Dr. Justice Jayashankaran Nambiar and Honorable Dr. Justice Kausar Edapath, Honorable Mr. Justice Siad Rahman, you all stayed here for the whole program. On behalf of all in the Kerala Judicial Academy and the Indian Law Institute, I express our deepest gratitude to you. My dear judicial officers, you are invited for this program, and I was talking with Mr. Advocate Parvati. She was saying that whether the judicial officers could understand what His Lordship has spoke about. I proudly said, my officers know what is the feeling of this third community, and what are their grievances, what are their feelings. We can completely resonate with them, because we are not persons disassociated from the society. We are the person always attached with the society, embedded with the feelings of the society. My dear officers, you all come to this venue. After receiving our invite, I express our deepest gratitude to you. Respected Additional AG, you are here throughout the program. On behalf of Kerala Judicial Academy and Indian Law Institute, I express our gratitude. My dear senior advocates, despite your full engagement, you spend time with us. So on behalf of all in the academy as well as in the Indian Law Institute, I express our deepest gratitude. My dearest lawyers, you all come here after accepting our invite. On behalf of both Academy and Indian Law Institute, I express our gratitude. My dear students, both law students as well as the other students, your presence, that is the real good thing of this event. You have asked the questions, you have lot of doubts, so you tried to clear with them. I am sorry that we cannot allocate more time to you to get it clarified from your lordships. Your presence is a real delight. On behalf of all in the Academy and Indian Law Institute, I express our deepest gratitude to you. And all persons who have gathered here, all in this venue, on behalf of Academy and Indian Law Institute, I express our deepest gratitude. Thank you all once again for having come here and listening a splendid event organized by the Indian Law Institute and the Kerala Judicial Academy. Thank you. Jai Hind.